everybody. Our group will report about adoption. So first, we'll start with the definition about adoption and then the motherhood provisions in the Constitution, in international law, on the welfare of the child, etc. Then we proceed to exploring. We ask the question, why do people resort to adoption? And finally, we move on to the erroneous practices vis-a-vis adoption. And then from there on, we proceed to the other reporters in our group. So first, adoption. Adoption is a process whereby a person assumes the parenting of another, usually a child, from that person's biological or legal parent or parents. Legal adoptions permanently transfer all rights and responsibilities along with affiliation from the biological parent or parents. In the Philippines, adoption is a process of granting social, emotional, and legal family and kinship membership to an individual in the Philippines, usually a child. It involves a transfer of parental rights and obligations and provides family membership. The Department of Social Welfare and Development, or DSWD, defines adoption as a social-legal process of giving permanent family to a child whose parents have voluntarily or involuntarily given up their parental rights. RA number 8552, or the Domestic Adoption Act of 1998, recognizes that children should grow up with their biological parents. However, should the efforts of biological parents to raise their child be insufficient, other members of the extended family may take on the responsibility of parenthood for the child. It is only when members of the extended family are not available that adoption by non-relatives is allowed to take place. There are several types of adoption in the Philippines. Say for instance, agency adoption and relative adoption. Agency adoption and relative adoption. Agency adoption refers to the procedure by which a legally accredited agency finds potential families or foster families for children who are put up for adoption. On the other hand, relative adoption is when the biological parents of a child renounce their claim over the child to a relative or a member of their extended family. There's also inter-country adoption. It is the process by matching a child with a family outside of the Philippines, and usually this is done through collaboration of local and foreign adoption agencies. We ask the question, who may adopt? Article 27 of PD 603, or the Child and Youth Welfare Code, provides who may adopt. Any person of age and in full possession of his civil rights may adopt, provided that he is in a position to support and care for his legitimated, acknowledged natural children or natural children by legal fiction or other illegitimate children, in keeping with the means, both material and otherwise, of the family. In all cases of adoption, the adopter must be at least 15 years older than the person to be adopted. Who may not adopt? We proceed to Article 28 of PD 603. It states, the following persons may not adopt. Number 1, a married person without the written consent of the spouse. Number 2, the guardian with respect to the ward prior to final approval of his accounts. Number 3, any person who has been convicted of a crime involving moral turpitude. And number 4, an alien who is disqualified to adopt according to the laws of his own country, or one with whose government the Republic of the Philippines has broken diplomatic relations. We go to the effect of adoption. Adoption has the following effects on parental authority and succession. Article 39 of PD 603 provides for the effects of adoption. Number 1, it will give the adopted person the same rights and duties as if he were a legitimate child of the adopter, provided that an adopted child cannot acquire Philippine citizenship by virtue of such adoption. Number 2, It dissolves the authority vested in the natural parent or parents, except where the adopter is the spouse of the surviving natural parent. Number 3, it entitles the adopted person to use the adopter's surname. And number 4, it makes the adopted person a legal heir of the adopter, provided that if the adopter is survived by legitimate parents or ascendants and by an adopted person, the latter shall not have more successional rights than an acknowledged natural child, provided further that any property received gratuitously by the adopted from the adopter shall revert to the adopter should the former predecease the latter without legitimate issue, unless the adopted has during his lifetime alienated such property. And provided finally that in the last case, should the adopted leave no property other than that received from the adopter, and he is survived by illegitimate issue or a spouse, such illegitimate issue, collectively or the spouse, shall receive 1/4 of such property. If the adopted is survived by illegitimate issue and the spouse, then the former collectively shall receive 1/4 and the latter also 1/4. The rest in any case reverting to the adopter, observing in the case of the illegitimate issue the proportion provided for in Article 895 of the Civil Code. The adopter shall not be a legal heir of the adopted person whose parents by nature shall inherit from him, except if the latter are both dead, the adopting parent or parents take the place of the natural parents in the line of succession, whether testate or intestate. Now the motherhood statements. Paragraph 2, Section 3, Article 15 of the 1987 Constitution provides, the state shall defend the right of children to assistance, including proper care and nutrition, and special protection from all forms of neglect, abuse, cruelty, exploitation, and other conditions prejudicial to their development. Next, we go to the Philippines, being a party to the United Nations Convention of the Rights of the Child. The UN upholds the following rights of a child. Number 1, every child has the right to be born well. Number 2, every child has the right to a wholesome family life. Number 3, every child has the right to be raised well and become contributing members of society. Every child has the right to basic needs, and every child has the right to access what they need to have a good life. Further, every child has the right to education. Every child has the right to play and enjoy their youth. Also, every child has the right to be protected from danger and to live in a productive environment. Every child has the right to be cared for in the absence of their parent or guardian, and every child has the right to good governance. Every child, finally, has the right to freedom and peace. The rights of a child are anchored on 4 core principles. Number 1, non-discrimination. Number 2, devotion to the best interests of the child. Number 3, the right to life, survival and development. And finally, number 4, respect for the views of the child. The question is invariably asked, why do people resort to adoption? Couples resort to adoption for the following reasons. Number 1, couples resort to adoption because of infertility. Number 2, some women have medical conditions that make it dangerous for them to carry a pregnancy. Number 3, they don't want to pass down genetic disorders or diseases. Number 4, they are same-sex couples and want to become parents. Number 5, they want to give a child a loving home. Number 6, they want to help pregnant women with unplanned pregnancy to pursue their life goals. And number 7, they want to help a friend or family member who is not in a position to raise a child. Number 8, they want to help one of the thousands of children without permanent families. Number 9, they want to raise an older child rather than an infant. Number 10, they want to choose the gender of their child. Number 11, the adoption process has more potential for success than infertility treatments. Number 12, they want to adopt a stepchild. Number 13, they want to adopt an adult with whom they have a long-established parent-child relationship with. Number 14, they want to help balance population growth. And number 15, they want to incorporate multiple races, cultures, and ethnicities to their family. Number 16, they feel called to adopt for religious or other reasons. 17, they decide becoming parents is more important than becoming pregnant. Number 18, they know others who were adopted or have adopted and see it as a positive way to grow a family. Number 19, they were adopted and want to give the same experience to someone else. And number 20, they just want to. Now, there are several erroneous practices in adoption. In the Philippines, couples resort to illegal adoption, citing the tedious and costly process to adopt a child. Common erroneous practices. Number 1, delayed registration of the adopted child. The effect of delayed registration would result to 2 birth certificates of the child. Number 2, simulation of birth, on the other hand, is the tampering of the civil registry to make it appear in the birth records that a certain child was born to a person who is not his biological mother, thus causing such child to lose his true identity and status. This is resorted to by persons who do not want to go through a tedious and costly process of adoption. Congress, however, has passed a law to rectify simulated birth certificates. RA number 11222, otherwise known as an act allowing the rectification of simulated birth records and prescribing administrative adoption proceedings, aims to, number A, to grant amnesty and allow the rectification of the simulated birth of a child where the simulation was made for the best interest of the child and that such child has been consistently considered and treated by the person or persons who simulated such birth as her, his, or their own daughter or son. B, to fix the status and filiation of a child whose birth was simulated by giving such child all the benefits of adoption and ensuring that the child shall be entitled to all the rights provided by law to legally adopted children without any discrimination of any kind, as well as to love, guidance, and support from the child's adoptive family. C, to exempt from criminal, civil, and administrative liability those who simulated the birth record of a child prior to the effectivity of the Act, provided that a petition for adoption with an application for the rectification of the simulated birth record is filed within 10 years from the effectivity of the Act. To provide for and allow a simpler and less costly administrative adoption proceeding where the child has been living with a person or persons who simulated her or his birth record for at least 3 years before the effectivity of the Act, and E, to educate and inform the public about the rectification of simulated births and to encourage people to avail of the benefits of the Act. So, my friends, there are several types of adoption in the Philippines. I would like to recap. Number 1, agency adoption. Number 2, relative adoption. Number 3, inter-country adoption. Number 4, independent adoption. And number 5, rectification. These are the ways by which a child can be adopted in the Philippines. Now to the next reporter. Take it away.
Good evening, Dean. Good evening, classmates. Assalamu alaikum. This is Abdul Bari Habib, and tonight I will report about the different types of domestic adoption in the Philippines. Adoption, as we know it, is one of the most selfless and beautiful acts that a person can do, since through adoption, a child who is deprived of family life is given an opportunity to have a permanent home and family who can give him or her love, support, security and protection, identity, and opportunities for growth and development. But adopting a child is not an easy task. The process of adoption is not as simple as merely surrendering the custody of a child to another person. It is actually more than that. There are a number of steps that must be taken in order for the adoption to be successful. So, whether a person is looking to start a family through adoption or looking to add to his or her existing family, he or she needs to know exactly what is involved before beginning any type of adoption procedures. So tonight, I will discuss some of the things that one might need to know about domestic adoption in the Philippines. Particularly, I will discuss the types of domestic adoption in the Philippines, the procedures in adoption, the list of requirements to be submitted to the DSWD, and the role of DSWD in adoption. Now, there are three types of domestic adoption recognized in the Philippines, and these are agency adoption, relative adoption, and independent adoption. Agency adoption refers to the procedure of placing or adopting a child through a licensed adoption agency as facilitated by the DSWD. Here, it is the adoption agency which finds and develops adoptive families for children who were put up for adoption. So, in this type of adoption, the adoptive families generally go through a process from application as prospective adoptive family before the DSWD to finalization of the child's adoption in court. And through this type of adoption, the legal rights of the child, the adoptive parents, and the biological parents are all equally protected. So later on, I will discuss in detail the process or procedure involved in agency adoption. The next is relative adoption, or also known as family adoption. It refers to the direct placement of a child to a relative or a member of the extended family within the fourth degree of consanguinity. So, if in agency adoption, it is the adoption agency which finds adoptive family for a child who is put up for adoption, here in relative adoption, it is actually the biological parents which make the direct placement of their child to the adoptive family, which must be a relative of the biological parents within the fourth degree of consanguinity. In other words, relative adoption is the legal adoption of a child by a close family member. So this type of adoption is directly filed in court and does not require the applicant to go through the DSWD process, which makes it less rigorous as compared to agency adoption. The third type of domestic adoption is independent adoption, and it refers to the direct placement of a child with a person known by the biological parents or with a stranger encountered through an intermediary. So, this is somewhat similar to relative adoption in the sense that it is also the biological parents who directly place their child to the adoptive family. The difference is that in relative adoption, the adoptive parent is a blood relative of the biological parents within the fourth degree of consanguinity, while here in independent adoption, such is not the case. Here, the child is either placed to an adoptive parent who is an acquaintance of the biological parents or to a stranger who is known by the biological parents through an intermediary. This intermediary is a person who knows of parents who want to adopt a child and is the one who arranges the placement between the biological parents, the adoptive parents, and the child. So in terms of how its process is facilitated, independent adoption shares a lot of similarities to relative adoption. It is also processed through directly filing a petition to adopt with the family court. And here also, the DSWD does not have to be involved unless ordered by the court. Now, let us discuss the procedure in agency adoption. Unlike in the case of relative and independent adoptions, which are directly filed with the family court, in agency adoption, the prospective adoptive parents must first pass through the DSWD before they can file the petition for adoption in court. So, the process here is generally divided into two. First is the administrative phase, which is done through the DSWD, while second is the judicial phase, which is done obviously in court. So in agency adoption, potential adoptive parents must go through several steps, the first of which is to undergo pre-adoption services as required under the Domestic Adoption Act of 1998. These pre-adoption services refer to the psychological services provided for by the DSWD, the purpose of which is to ensure that no hasty decisions caused by anxiety or stress are made by the biological parents or the prospective parents, and also to ensure the mental and emotional well-being of the parties involved throughout the entire adoption process. So the services included here are the counseling of the biological parents, the counseling of the prospective adoptive parents, as well as their attendance in a seminar forum, and the counseling of the child. After completing the counseling and seminar forum, the prospective adoptive parents may now submit their application for adoption before the DSWD field office or at any licensed child placing agency. Once the application is filed, the social worker will then assess the applicants and will prepare a home study report which will indicate the situation and family background of the prospective adoptive parents, as well as their motivation and capacity to provide a home that meets the needs of the child. Here, the applicants will be subjected to individual and joint interviews, as well as home visits and collateral interviews. After the home study report is done, it will now be submitted to the DSWD for approval. Once approved, the matching process will now begin. Here, there will be a matching case conference where the home study report will be presented to match the prospective adopters with a child legally free for adoption. In this stage, the adopters are asked to specify their preferences in the child with whom they will be matched. They will also be asked if they are willing to adopt a child who has a developmental delay or has disability. Upon the completion of the matching process, the social workers are then required to prepare the adoptive family and the child for placement where the child is physically transferred from the child caring or foster home to the prospective adoptive parents. Once the DSWD has approved the placement, the department will then issue the pre-adoption placement authority to transfer parental responsibility to the adoptive parents. This also marks the beginning of the supervised trial custody, which is the next stage. So at the supervised trial custody, the assigned social worker will conduct monthly home visit for a period of 6 months. This is to monitor the adjustment and emotional preparedness of both the adopters and the adoptee in their new familial relationship. And upon the termination of the 6-month period of supervised trial custody, the consent to adopt shall then be issued by the DSWD. So the issuance of the certificate of consent to adoption marks the end of the administrative phase and signifies the start of the judicial phase, which is commenced by the filing of a petition for adoption before the family court of the province or city where the adopters reside. So this petition for adoption must be filed within 30 days after the receipt of the consent to adopt. And this is also the only point when the services of a lawyer are needed. So after the petition has been filed, the next step is the publication and hearing. Take note that the court shall only proceed to hear the petition once the order of hearing has been published in a newspaper of general circulation once a week for 3 consecutive weeks, and that all stipulated requirements has been met. Here, it is required that both the petitioner and the potential adoptee must be present during the hearing so that the court may be able to better gauge the child's condition both individually and relative to the petitioner. And if the court is convinced that the adopters are qualified to adopt and that the adoption would redound to the best interest of the child, a decree of adoption shall be issued, which will be effective as of the date of filing of the petition for adoption. And this decree of adoption completes the process of adoption, as the petitioner can now legally refer to the adoptee as his or her own child. And finally, the last step in the adoption process is the post-adoption services. This is the psychosocial and support services provided for by a professionally trained social workers to the adoptee, the adoptive parents, and the biological parents after the adoption is legally completed. And the services included here are counseling, parents group sessions, referrals, and assisting in the search of the child's birth family if not known and if so requested. Now, let us go to the requirements that must be submitted to the DSWD. For prospective adoptive parents, these are application form, home study report, authenticated birth certificate, marriage contract or divorce papers, annulment decree, declaration of nullity of marriage or legal separation documents, written consent to the adoption by the children of the applicant who is at least 10 years old, physical and medical evaluation, NBI or police clearance, latest income tax return, 3 character references, pictures of the applicant and his or her immediate family, and certificate of attendance to pre-adoption forum or seminar. For alien applicants, the additional requirements are certification that the applicants have legal capacity to adopt, certificate of residence in the Philippines issued by the Bureau of Immigration or the Department of Foreign Affairs, 2 character references, and police clearance from all places of residence. As for the prospective adopted child, the requirements are child study report, authenticated birth certificate or foundling certificate, written consent to the adoption by the biological parents or the legal guardian, and the written consent of the child if at least 10 years old, death certificate of biological parents or degree of abandonment or deed of voluntary commitment as appropriate, medical evaluation, psychological evaluation, and picture of the child. So what is the role of the DSWD insofar as adoption is concerned? Under the Domestic Adoption Act of 1998, the DSWD has the duty to implement the adoption program, to facilitate the provision of immediate and permanent placement of a child legally available for adoption, and to provide a license for adoption agencies who are allowed to facilitate agency adoption. And that ends my report. Thank you very much for listening.
Hello everyone. I will now be discussing to you the evolution of domestic adoption laws. In particular, I will be discussing the old Civil Code, the new Civil Code, the Child and Youth Welfare Code, and then the Family Code. So we have the old Civil Code of the Philippines. This was enforced in 1889 when the Philippines was still a colony of Spain. And then we have the new Civil Code of the Philippines, which became effective in August 30, 1950. And then Presidential Decree number 603, otherwise known as the Child and Youth Welfare Code of 1974. And then we have Executive Order number 209, or the Family Code of the Philippines, signed into law on July 6, 1987. These are the points that we are going to look into as we compare the provisions on domestic adoption in these laws. Who may adopt? Who may not adopt? Who may be adopted? Who may not be adopted? We will also go into consent, the effects of adoption and succession, rescission and revocation, and then we go into procedure by which domestic adoption shall be made, and then records, and then termination of parental authority. Okay, who may adopt? So let us compare the provisions in these 4 laws. So looking at the screen or looking at these provisions right now in front of you, we can very well see that from the old Civil Code, the mandate was that only those persons who are in the full exercise of their civil rights are to be allowed to adopt. And take note that in the old Civil Code, in fact, there is an age requirement. All right? So those who are over 45 years of age, those are the only persons that are allowed to adopt. And in fact, the age gap must also be at least 15 years of age between the adopter and the adopted. We go into the new civil code and even into PD 603, we can see this very same provision replicated, only that there are more details incorporated in PD 603, as we can see on the screen right now as a reference into that particular provision, in particular Article 27. So there are requirements of the capability of the adopter to support, to care for legitimated, acknowledged natural children or natural children, and many other things. Right? So the same gap of age is also required between the adopter and the adopted. And we go into the current family code, we see the same provisions echoed. Okay? So only that in the family code, the adopter must be at least 16 years older than the person to be adopted. Unless, of course, the adopter is a parent by nature of the adopted or is the spouse of the legitimate parent of the person to be adopted. Let's now go into the question of who may not adopt, or the provision of who may not adopt. Okay? So note that it started in the old civil code of a list of only 4 category of persons who are not allowed to adopt or where adoption is forbidden. In the new civil code, it expanded, or it is more elaborate, because you can now see 6 persons who are forbidden or who are not allowed to adopt. Okay? And then going to the Child Welfare Code, it is practically the same. It just actually condensed what was provided for in the new civil code. And then finally, in the family code, you now have, in particular, 3 categories of persons who may not adopt. We have the guardian with respect to the ward prior to the approval of the final accounts rendered upon the termination of the guardianship relation. And any person who has been convicted of a crime involving moral turpitude. So this person cannot also be allowed to adopt. And then we have an alien. An alien is allowed domestic adoption, save for some exceptions. As enumerated herein, there are 3. Okay? So these are the provisions on these 4 laws as far as the question of who may not adopt is concerned. We now go into adoption by husband and wife. Now, adoption by husband and wife is, of course, permitted. Okay, let us now look at the evolution. So, from the old civil code going to the new civil code, it expressly provides that husband and wife may jointly adopt. And parental authority likewise shall be jointly exercised by the husband and the wife as if that adopted child were their own by nature. And also echoed in PD 603. And then finally in the family code, it is likewise provided that husband and wife must jointly adopt with some exceptions. 1, when one spouse seeks to adopt his own illegitimate child, or when one spouse seeks to adopt the legitimate child of the other. Okay? In case the husband and the wife jointly adopt, or one spouse adopts the legitimate child of the other, joint parental authority shall be exercised by the spouses pursuant to the provisions of the family code. Now, who may not be adopted. Okay, we can see we can see provisions into this particular matter beginning the new civil code, in particular Article 339 thereof. So, who cannot be adopted? One, a married person without the written consent of the other spouse, an alien with whose government the Republic of the Philippines has broken diplomatic relations, and a person who has already been adopted. Looking into PD 603, again, we can see that the provisions in RA 386 are also echoed. Let us go into the family code. Right, these are the provisions pertaining to the question of who may not be adopted. So, a person of legal age, unless that person is a child by nature of the adopter or his or her spouse, or prior to the adoption, that person has been consistently considered and treated by the adopter as his or her own child during minority. An alien, same with that of the new civil code and PD 603. And then finally, a person who has already been adopted, also the same, unless the adoption has been previously revoked or rescinded. Now, the question of consent, okay? Consent in the adoption. Let us go into the old civil code, right? Article 178 thereof provides that the adoption shall be made with judicial authorization, and it must necessarily state the consent of the adopted when of age. However, when the adopted is a minor, that of the persons who must give consent to the minor's marriage, and when incapable, that of the guardian is necessary. Okay? Let us go into the new civil code. Article 340 thereof requires written consent to the adoption shall be made or is necessary the person to be adopted if 14 years of age or over, and the parents, guardian, or person in charge of the person to be adopted. So the written consent of these persons to the adoption are necessary or shall be necessary. Let's go into PD 603. So in PD 603, we can definitely see that the provisions on the new civil code is likewise replicated as far as consent is concerned, especially if the person to be adopted is if 14 years of age or over. Okay, and as to who shall give consent, it's also indicated in PD 603. And the natural children, okay, of the adopting parents must also give consent if they are 14 years and above. Now, as to the provisions of the family code, the age is different. And it is if the person to be adopted is 10 years of age or over, written consent to the adoption shall be necessary, coming from the person and also the parents by nature of the child, the legal guardian, or the proper government instrumentality. And if the adopting parent or parents have legitimate and adopted children 10 years of age or over, their consent is also necessary. Illegitimate children of the adopting parent, if living with the said parent and the latter spouse, if any, and if also 10 years of age or over, is also necessary. And finally, the spouse, if any of the person adopting or to be adopted. So these are the salient provisions of these four laws as far as consent is concerned. Let's go on into the effects of adoption and even on the aspect of succession. Okay? So, among others, what is common in these four laws is that the adopted may bear the surname of the adopter. Okay, you can see this in the provisions of the old civil code, the new civil code, in the child and youth welfare code, or even in the family code. And likewise, you can glean that it is common amongst these four laws that the parents by nature are already or are divested with parental authority once adoption will be had or will be approved. And that if you go into the child welfare code, the provisions on the effects are more elaborate in terms of succession. And I will be going over the provisions on succession separately. Right? Let us first go into the family code. So same, in the family code, you can readily see in the provisions that the adopted is elevated into the status of a legitimate child of the adopters, and both the adopter and the adopted acquire reciprocal rights and obligations arising from the relationship of parent and child, including, again, the right to use the surname of the adopters. And same with the previous or the three other laws, the parents by nature, their parental authority shall be terminated and be vested in the adopters. And finally, the adopted shall remain an intestate heir of his natural parents and other blood relatives. Now, as I mentioned earlier, let me go over the salient provisions of these four laws as far as succession is concerned. Okay? So in the old civil code, in particular Article 177 thereof, the adopter, it is explicitly provided that the adopter acquires no right to inherit from the adopted. Neither does the adopted acquire any right to inherit from the adopter unless by will, excepting when the adopter in the deed of adoption has obliged himself to institute him as an heir. Okay? So these obligations shall produce no effect when the adopted dies before the adopter. The adopted retains all the rights belonging to him in his original or natural family, excepting those referring to the parental power. Now, in the new civil code, there are some variances, and let us look into some of the provisions in Republic Act 386. Okay, so it is indicated in the new civil code that the adopter, as far as succession is concerned, shall not be again a legal heir of the adopted person. His parents by nature shall inherit from him. Okay? If the adopter is, however, survived by legitimate parents or ascendants and by an adopted person, the latter shall not have more successional rights than an acknowledged natural child. It is also mentioned in the new civil code that the adopter may donate property by an act inter vivos to the adopted person who shall acquire ownership thereof. And in case of the death of an adopted child and leaving no children or descendants, his parents and relatives by consanguinity and not by adoption shall be his legal heirs. Now, in PD 603, additional provision, it is indicated in this particular law that the adopted person, it makes the adopted person a legal heir of the adopter with some conditions or some specific requirements. Let us now look into the provisions of the family code. It's quite lengthy, but let us look into the salient points herein. Okay, so these are very specific provisions detailing the share whenever there is a concurrence of, say, the parents or ascendants, legitimate or illegitimate, and that of the adopted adopter. So these are specific provisions wherein we can readily see, or we can readily lift up the sharing. Like for example, if legitimate and illegitimate children and descendants and the surviving spouse of the adopted, okay, they shall inherit from the adopted in accordance with the ordinary rules of legal or intestate succession. Let us take a look at this particular case. Say when the parents, legitimate or illegitimate, or the legitimate ascendants of the adopted concur with the adopter, they shall divide the entire estate, one half to be inherited by the parents or ascendants, and the other half by the adopters. So if you go into the succeeding provisions or items in Article 190, it will just detail the sharing as to whoever survives upon, let's say, the death of the adopted. So this is all about succession. Let us now go into rescission and revocation. Okay. This provides for conditions and requirements whereby an adopted can rescind the adoption, or an adopter can petition the court for revocation. So it just details, or these rather provisions detail in these different laws, from the Old Civil Code up to the Family Code, the requirements or conditions whereby either rescission or revocation can be had. Now, of course, it distinguishes when the adopted is a minor still or incapable, or the adopted is already of age. So the requirements or the conditions in seeking for a rescission varies only insofar as who may bring the rescission of the adoption. Okay, as to grounds of rescission in the Old Civil Code, the same grounds that cause the loss of parental authority are the very same grounds that can be invoked in rescission of the adoption. And the new Civil Code, okay, there is Article 348, which details when an adopter may petition the court for revocation of the adoption. So it also enumerates the grounds by which this can be done. PD 603 is more elaborate. It really has specific provisions on the rescission by the adopted and the revocation by adopter. So the requirements are laid out. And it likewise provides for the effects of rescission or revocation. Let us go into the Family Code. So there are provisions from the previous or the antecedent laws, the prior laws, that are also echoed in the Family Code, which is, of course, the code in effect right now. So see, it distinguishes the requirements when you have an adopted seeking for a rescission when he or she is a minor or otherwise incapacitated, compared to that if the adopted seeking for rescission is already of age. Okay, so say the adopted is already at least 18 years of age, he may or she may petition for judicial rescission of the adoption on his own, okay, on the same grounds prescribed for disinheriting an ascendant as provided also in the Family Code. And in another provision of the Family Code, in particular Article 192, this provides when adopters may petition the court for judicial rescission of the adoption. Okay, so it likewise details the requirements. As to procedure, alright, so procedure in the old civil code, the adoption shall be made with judicial authorization, and it must necessarily state the consent of the adopted, again, when of age. In comparison to when the adopted is a minor, that of the persons who must give consent to the minor's marriage, and when incapable, that of the guardian, are those that shall give or extend the consent, okay, for the adoption. In the new civil code, in Article 345 thereof, it specifically states that proceedings for adoption shall be governed by the rules of court. Okay, insofar, of course, as the rules are not in conflict with the new civil code. Now, again, like in like in the previous discussion, PD 603 is more elaborate as far as procedure for domestic adoption is concerned. It details provisions on hurried decisions, meaning to say it mandates proceedings for adoption, like in particular the court, to take the necessary steps to ensure that that natural parents are not making hurried decisions as far as domestic adoption is concerned. It also requires case study. Okay, so case study is mandated on the Department of Social Welfare, then Department of Social Welfare, or the Social Work and Counseling Division in case of juvenile and domestic relations court. So this is the requirement of case study in PD 603. Okay, trial custody. So you see, in terms of procedure, so it shall also be governed in the rules of court, saying in the new civil code. There are other requirements, however, or provisions, however, in PD 603, like for example, trial custody. So it states elaborately that no petition for adoption shall be finally granted unless and until the adopting parents are given with the court a supervised trial custody period for at least 6 months to assess their adjustment and emotional readiness for the adoption or the legal union between the adopter and the adopted. So this is peculiar in PD 603. Before a degree of adoption will be had. Records, of course, when you have now adoption or after adoption proceedings, it will now be affecting, of course, the corresponding record in the local civil registry. So you can find this common from the old civil code to the new civil code, and also in the child and youth welfare code, which, apart from indicating or stating that the adoption shall be recorded in the local civil register and shall be annotated on the record of birth, it shall also entitle the adopted person for the issuance of an amended certificate of birth. And it explicitly provides of the confidential nature of the adoption proceedings and records. Okay, termination of parental authority. Let us go into this. Well, if you take a look at the provisions or salient provisions of the old civil code, the new civil code, the child and youth welfare code, and even up to the family code on this particular matter, they are common. So when does parental authority terminate? It is by death. Well, we are pertaining here to natural parents, of course. First, in the old civil code, we can see in Article 167, 3 items therein. by death of the parents of the child, emancipation, and adoption of the child. And in the new civil code, the same items are replicated except that there's an addition that parental authority also terminates upon the appointment of a general guardian. And in the family code, you can also, of course, very well and readily see that the same provisions are again replicated with the addition, like in item number 3, Article 229, upon judicial declaration of abandonment of the child in a case filed for the purpose. Okay, so that's one way by which parental authority shall be terminated. Also, it provides that upon final judgment of a competent court divesting the party concerned of parental authority, this is another one. And finally, upon judicial declaration of absence or incapacity of the person exercising parental authority. So that's all about the evolution of domestic adoption laws as far as the old civil code is concerned, and then going into the new civil code, the child and youth welfare code, and finally the family code. Again, those are the salient provisions of the said laws and how domestic adoption evolved from the old civil code to the new civil code, to the child and youth welfare code, and finally to the current family code of the Philippines.
Good evening. Tonight I will be discussing in a nutshell Republic Act number 8552, otherwise known as the Domestic Adoption Act, Republic Act number 9523, or the Act requiring certification of the Department of Social Welfare and Development to declare a child legally available for adoption as a prerequisite for adoption proceedings, as well as Republic Act number 10165, or the Foster Care Act of 2012. They say that the family is not defined by our genes. It is built and maintained through love. A beautiful definition of adoption is building a family through the process of concentrated, dedicated, enduring love rather than biology. Who may adopt? Any Filipino citizen of legal age, in possession of full civil capacity and legal rights, and of good moral character, and has not been convicted of any crime involving moral turpitude, who is emotionally and psychologically capable of caring for children, and at least 16 years older than the adoptee, and who is in position to support and care for his or her children in keeping with the means of the family may adopt. An alien may also adopt, provided that he possesses the same qualifications stated for Filipino nationals, and provided that his or her country has diplomatic relations with the Republic of the Philippines, that he or she has been living in the Philippines for at least 3 continuous years prior to the filing of the application for adoption, and maintains such residence until the adoption decree is entered. It is also required that he or she has been certified by his or her diplomatic or consular office or any appropriate government agency that he or she has the legal capacity to adopt in his or her country, and that his or her government allows the adoptee to enter his or her country as his or her adopted son or daughter. It is worthy to note that the requirements in residence certification of the alien's qualifications to adopt in his or her country may be waived for the following: a former Filipino citizen who seeks to adopt a relative within the fourth degree of consanguinity or affinity; by one who seeks to adopt the legitimate son or daughter of his or her Filipino spouse; by one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse a relative within the fourth degree of consanguinity or affinity of the Filipino spouse; or the guardian with respect to the ward after the termination of the guardianship and clearance of his or her financial accountabilities. The law requires that the husband and wife shall jointly adopt, except in the following cases: if one spouse seeks to adopt the legitimate son or daughter of the other. Second, if one spouse seeks to adopt his or her own illegitimate son or daughter, provided, however, that the other spouse has signified his or her consent thereto, or if the spouses are legally separated from each other. In case husband and wife jointly adopt, or one spouse adopts the illegitimate son or daughter of the other, joint parental authority shall be exercised by the spouses. Who may be adopted? Any person below 18 years of age who has been administratively or judicially declared available for adoption. The legitimate son or daughter of one spouse by the other spouse. An illegitimate son or daughter by a qualified adopter to improve his or her status to that of legitimacy. A person of legal age if, prior to the adoption, said person has been consistently considered and treated by the adopter or adopters as his or her own child since minority. A child whose adoption has been previously rescinded. Or a child whose biological or adoptive parent or parents has died, provided that no proceedings shall be initiated within 6 months from the time of death of the said parent or parents. Who is a child legally available for adoption? Republic Act Number 9523 amended the Domestic Adoption Act, Intercountry Adoption Act, and the Child and Youth Welfare Code by now requiring a certification from the Department of Social Welfare and Development that the prospective adoptee is a child legally available for adoption as a prerequisite for adoption proceedings. A child legally available for adoption refers to a child in whose favor a certification was issued by the DSWD that he or she is legally available for adoption after the fact of abandonment or neglect has been proven through the submission of pertinent documents, or one who was voluntarily committed by his or her parent or parents or legal guardian. Documents for adoptive parent or parents required by the Department of Social Welfare and Development. First is the application form, the birth certificate, the marriage certificate, divorce, annulment, declaration of nullity or legal separation documents, if any, written consent to adoption, medical certificate issued at least 6 months prior to the date of the filing of the application, latest income tax return or certificate of employment, National Bureau of Investigation clearance or police clearance issued at least 1 year prior to the application, 3 letters of character references, 3 by 5-inch sized whole body photos of the applicant and, where applicable, his or her family taken within the last 3 months, and a certification of attendance to adoption forum or seminars. For alien applicants, additional requirements for certification that the applicant or applicants have legal capacity to adopt, a certificate of residence in the Philippines issued by the Bureau of Immigration or the Department of Foreign Affairs, 2 character references from non-relatives who know the applicant or applicants in the country of which he or she is a citizen or was a resident prior to residing in the Philippines, except for those who have resided in the Philippines for more than 15 years, and lastly, police clearance from all places of residence. Procedure for adoption before the Department of Social Welfare and Development. First is the attendance in adoption forum or seminar conducted by the DSWD. Submission of application for adoption to the DSWD field office or to a child placing agency. Preparation of home study report. Submission of case records of prospective adoptive parents to the adoption resource and referral section of the DSWD. Matching. Regional, then interregional. Placement. Post-placement visits. And then consent to adoption. After that, filing of the petition for adoption in court. Then, issuance of decree of adoption and entry of judgment. After the entry of judgment, post-adoption services are conducted again by the DSWD. Republic Act Number 10165, otherwise known as the Foster Care Act of 2012. You can help save children through foster care. What is foster care? It refers to the provision of planned temporary substitute parental care to a child by a licensed foster parent to provide every child who is neglected, abused, surrendered, dependent, abandoned, under socio-cultural difficulties, or with special needs, with an alternative family that will provide love and care as well as opportunities for growth and development as an important step towards the child's return and reintegration to his biological parents or placement with an adoptive family. Who may be a foster parent? An applicant who meets all of the following qualifications may be a foster parent. Must be of legal age. Must be at least 16 years older than the child, unless the foster parent is a relative. Must have a genuine interest, capacity, and commitment in parenting, and is able to provide a familial atmosphere for the child. Must have a healthy and harmonious relationship with each family member living with him or her. Must be of good moral character. Must be physically and mentally capable and emotionally mature. must have sufficient resources to be able to provide for the family's needs, must be willing to further hone or be trained on knowledge, attitudes, and skills in caring for a child, and must not already have the maximum number of children under his foster care at the time of application or award, as may be provided in the implementing rules and regulations of this Act. Provided that in determining who is the best suited foster parent, the relatives of the child shall be given priority, so long as they meet the above qualifications, and provided further that an alien possessing the above qualifications and who has resided in the Philippines for at least 12 continuous months and maintains such residence until the termination of placement by the DSWD or expiration of the foster family license may qualify as a foster parent. Who may be placed under foster care? A child who is abandoned, surrendered, neglected, dependent, or orphaned. A child who is a victim of sexual, physical, or any other form of abuse or exploitation. A child with special needs. A child whose family members are temporarily or permanently unable or unwilling to provide the child with adequate care. A child awaiting adoptive placement and who would have to be prepared for family life. A child who needs long-term care and close family ties, but who cannot be placed for domestic adoption. A child whose adoption has been disrupted. A child who is under socially difficult circumstances, such as but not limited to a street child, a child in armed conflict, or a victim of child labor or trafficking. A child who committed a minor offense but is released on recognizance, or who is in custody, supervision, or whose case is dismissed. And a child who is in need of special protection as assessed by a social worker, an agency, or the DSWD, provided that in case of subsections B, C, F, H, I, and J, the child must have no family willing and capable of caring and providing for him. Requirements for foster parents: an application form, birth certificate, marriage certificate, divorce, annulment, declaration of nullity, or legal separation documents, if any. Medical certificate issued at least 6 months prior to the submission of the application form. Income tax return or certificate of employment. National Bureau of Investigation clearance or police clearance issued at least 1 year prior to the submission of the application form. Barangay certificate stating that the applicant is a resident of the barangay, length of his or her residence therein, that he or she is of good moral character, 3 by 5 inch sized whole body photos of the applicant, and, where applicable, his or her family taken within the last 3 months. Certificate of attendance to foster care forum. and additional requirements for alien applicants, certification of residence in the Philippines issued by the Bureau of Immigration or the Department of Foreign Affairs, and two character references from non-relatives who know the applicant or applicants in the country of which he or she is a citizen or was a resident prior to residing in the Philippines, except those who have resided in the Philippines for more than 15 years. Procedure: attendance in foster care forum or seminar, submission of application to the DSWD field office or child placing agency, submission of home study report, issuance of foster family care license, matching, placement, supervision of foster care placement, and finally, termination of placement. I will end with the thoughts and words of Khalil Gibran on children. Your children are not your children. They are the sons and daughters of life's longing for itself. They come through you, but not from you. And though they are with you yet, they belong not to you. You may give them your love, but not your thoughts, for they have their own thoughts. You may house their bodies, but not their souls, for their souls dwell in the house of tomorrow.
Good evening, Dean Mel Santamaria. Good evening, classmates. I'm attorney Donnie Wayne Villarin, and my reports about adoption, qualification and disqualifications of the adoptee and adopter, the necessity of consent and joint adoption of both parents. Adoption is the process of making a child, whether related or not to the adopter, possess in general the rights accorded to a legitimate child. Ordinarily, it is a juridical act, a proceeding in rem which creates between two persons a relationship similar to that which result from legitimate paternity and filiation. By way of exception, and pursuant to Republic Act No. 11222, or the Simulated Birth Rectification Act, the law now allows the filing of an administrative adoption upon compliance with certain requirements. The prevailing laws on adoption are Republic Act 8552 or the Domestic Adoption Act of 1998 and Republic Act 8043, the Inter-Country Adoption Act of 1995. Relevant also is the Family Code or the Executive Order 209 effective August 3, 1988, which repealed the substantive provisions of PD 603 and Executive Order 91 on adoption. The rule on adoption, effective August 22, 2002, guidelines issued by the Supreme Court in petitions for adoption. The rule repealed Rules 99 to 100. It covers domestic adoptions, Section 1 to 25, and inter-country adoption, Section 26 to 32. Who may adopt? Any Filipino citizen of legal age and at least 16 years older than the adoptee, provided however that the minimum age gap between the adopter and the adoptee may not be required or may be waived if the adopter is the biological parent or sibling of the adoptee or the spouse of the adoptee's parents. The adoptive parents must have the capacity to act and assume all the rights and duties incident to the exercise of parental authority. He must possess of good moral character and has not been convicted of any crime involving moral turpitude. The state should also ensure that the adopted parent is in position of support, educate, and care of his or her legitimate and illegitimate children and the child to be adopted in keeping with the means of the family, and has undergone pre-adoption services as required in Section 4 of the law. Any alien possessing the same qualifications as mentioned above stated for Filipino nationals may also adopt. However, in addition to these qualifications, an alien may adopt if he or she is a citizen of a state which has diplomatic relations with the Philippines, has been certified by his or her diplomatic or consular office or any appropriate agency that he or she is qualified to adopt in his or her country, and that his government will allow the adoptee to enter the adopter's country and reside therein permanently as an adopted child. Likewise, an adopted alien must have submitted the necessary clearances and such other certifications as may be required by the DSWD. The guardian may also adopt with respect to the wife. The following may be adopted. First, the child legally available for adoption. The child must have been declared a child legally available for adoption. The child may either a person below 18 years of age or person over 18 years of age but is unable to fully take care of himself or herself or protect himself or herself from abuse, neglect, cruelty, exploitation, or discrimination because of physical or mental disability or condition. The certification declaring a child legally available for adoption applies only to surrendered, abandoned, neglected, and dependent children as mentioned in Republic Act number 95/23. Any of the following proceedings in court does not require certification declaring a child legally available for adoption from DSWD. First, adoption of an illegitimate child by any of his or her biological parent, adoption of a child by his or her step-parent, adoption of a child by a relative within the fourth degree of consanguinity or affinity. Under Section 8 of Republic Act 95/23, the certification that a child is legally available for adoption shall be issued by the Department of Social Welfare and Development in lieu of judicial order, thus making the entire process administrative in nature. Under Section 8 of Republic Act number 9523, the certification that a child is legally available for adoption shall be issued by the Department of Social Welfare and Development in lieu of judicial order, thus making the entire proceedings administrative in nature. Under Section 8A of the Domestic Adoption Act, the declaration that a child is legally available for adoption can be had either judicially or administratively. Section 8A was expressly repealed, however, by Republic Act 95/23. Under the amendatory law, the process of declaring a child legally available for adoption has been made entirely administrative. The certification issued by the DSWD shall be for all intents and purposes the primary evidence that the child is legally available in domestic adoption proceeding as provided in Republic Act number 8552 or the Domestic Adoption Act, and the Inter-Country Adoption Proceeding as provided in Republic Act number 8043, Inter-Country Adoption Act. Adoption of relative. Our law does not prohibit relatives, either by blood or affinity, from adopting one or the other, such as adoption of the legitimate son or daughter of one spouse by the other spouse, adoption of one's own illegitimate child, or the adoption of a person consistently considered and treated by the adopter as his or her own child since minority. In the addition of the foregoing child, the adoptee may even be a person of legal age. Who else may be adopted? A child whose adoption has been previously rescinded. A child whose biological or adoptive parents has died. In the latter case, the law requires that the adoption proceedings shall be initiated within 6 months from the time of the death of the said parents. Requirement for supervised custody. In domestic adoption, the temporary protected custody of the prospective adopters is under the supervision of the court and shall last for a period of 6 months, which may be reduced by court motu proprio or upon motion of the party. If adopter is alien, the law mandatorily requires completion of 6-month trial custody and may not be reduced except if a former Filipino citizen seeks to adopt a relative within 4th degree of consanguinity or affinity, one who seeks to adopt the legitimate son or daughter of his or her Filipino spouse, or one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse a relative within the 4th degree of consanguinity or affinity of a Filipino spouse. Under Foster Care Act of 2012, Republic Act 1016, in case of adoption of foster child by designated foster parents, the trial custody period may be partially waived to the extent of period equivalent to the period in which the foster child has been under the care of the foster parents, provided, however, that a harmonious relationship exists between the foster child, foster parents, and where applicable, the foster family. Husband and wife must jointly adopt. Requirements of joint adoption by spouses. On the part of the spouses, they are required to jointly adopt. In the case of Enrique, petition for adoption of Michelle P. Lim and Michael Jude P. Lim, the court had the occasion to explain the requirement of joint adoption by husband and wife. According to the court, it is mandatory. The use of word shall in section 7 of DAA or the Domestic Adoption Act means that joint adoption by husband and wife is mandatory. The court also emphasized that the requirement of joint adoption is still mandatory even if the person to be adopted is already legal age and already freed from paternal authority. Exception to joint adoption. If one spouse seeks to adopt the legitimate son or daughter of the other, if one spouse seeks to adopt his or own illegitimate son or daughter, but the other spouse must give his consent, and if the spouses are legally separated from each other. In the adoption of one's own illegitimate child, the requirement of obtaining the consent of the other spouse is mandatory, according to the case of Castro versus Gregorio. According to the court, in all instances where it appears that a spouse attempts to adopt a child out of wedlock, the other spouse or the other legitimate children must personally notify through the personal service of summons. And it is not enough that they be deemed notified through constructive service. Otherwise, the court does not validly acquire jurisdiction over the proceedings and the decisions of the court is null and void. In case husband and wife jointly adopt or one spouse adopts the illegitimate child of the other, joint parental authority shall be exercised by the spouses. Is consent necessary? Biological parents of adoptee, if known. However, consent of biological parents, even if they are known, is not necessary if they have abandoned the child. This is according to the case of Lang versus Court of Appeals 298 Scrap 128 1998. Another is the adoptee. If 10 years of age or older, legitimate or adopted children of the adopter or adoptee, if 10 years old of age or older, and illegitimate children of adopter if living with him if 10 years of age or older, and also the spouse of the adopter or adoptee. Rules on preference in adoption. Rules of preference in adoption. Preference in favor of the extended family. If there's a real need for adoption, it is the policy of the state to prefer adoption by child extended family over adoption by unrelated person. Likewise, preference in favor of domestic adoption. Inter-country adoption shall be resorted only when domestic adoption of a child is not available, and inter-country adoption is the best interest of the child. Thank you, and God bless.
Good evening. I am Venerable P. Ilanan. My topic is about inter-country adoption. Inter-country adoption is referring to the socio-legal process of adopting a Filipino child by a foreigner or a Filipino citizen permanently residing abroad, where the petition is filed, the supervised trial custody is undertaken, and the decree of adoption is issued outside the Philippines. The law that governs inter-country adoption in the Philippines is Republic Act number 8043, or the Inter-Country Adoption Act of 1995. When to resort to inter-country adoption. The state aims to provide every neglected and abandoned child with a family that will provide such child with love and care, as well as opportunities for growth and development. Towards this end, effort shall be exerted to place the child with an adoptive family in the Philippines. However, when all possibilities for adoption of the child under the domestic adoption have been exhausted, and that inter-country adoption shall prove beneficial to the child's best interest, and shall serve and protect his or her fundamental rights, and that it is the only and last resort, inter-country adoption is resorted to. Best interest of the child above all else. For many, the benefits of adoption outweigh the risk. Through adoption, many childless couples have found a way to realize their dreams of raising a family. Adoption has also placed countless homeless Filipino children to the care of loving adoptive parents who are emotionally and financially ready to support them. It is because of these inherent benefits in adoption that Philippines takes a liberal view on inter-country adoption and promotes the same not only as an act that creates a relationship of paternity and filiations, but also one that aims at giving every prospective adoptee a chance at a better future. Along with the liberality accorded to adoption, the principle of best interest of the child pervades Philippine cases involving adoption and child custody. Philippine law mandates that in choosing the parent to whom custody is given, the welfare of the child should always be the paramount consideration, aside from the material resources as well as the moral and social situations of the prospective adoptive parent. All relevant circumstances that impact on the child's well-being and development are considered. It is in keeping with this principle that all programs on inter-country adoption are geared towards the betterment of the adopted child. The distinction between domestic adoption and inter-country adoption. Domestic adoption is governed by Republic Act number 8552, the Domestic Adoption Act of 1998. And the procedure is governed by Administrative Memorandum number 02-06-02-EC, issued on August 22, 2002. While inter-country adoption is governed by Republic Act 8043, the Inter-Country Adoption Act of 1995, and the procedure is governed by the amended implementing rules and regulations on the Inter-Country Adoption Act. The procedure applies to domestic adoption of Filipino children where the entire adoption process, beginning from the filing of the petition up to the issuance of the adoption decree, takes place in the Philippines. In inter-country adoption, it applies to adoption of a Filipino child in a foreign country, where the petition for adoption is filed, the supervised trial custody is undertaken, and the decree of adoption is issued outside of the Philippines. Who may be adopted? Under the domestic adoption, a child legally available for adoption may be adopted with the following requisites. The child must be below 18 years of age, judicially declared available for adoption with the following exceptions. He or she may be a legitimate son or daughter, one of the spouse or by the other spouse, an illegitimate son or daughter by the qualified adopter, or a person of legal age if prior to the adoption, said person has been consistently considered and treated by the adopter as his or her own child since minority. While under the inter-country adoption, only legally free child may be adopted. Who is a legally free child? A child legally available for adoption refers to a child in whose favor a certification was issued by the Department of Social Welfare and Development that he or she is legally available for adoption after the fact of abandonment or neglect has been proven through the submission of pertinent documents. The following requisites are: he must be below 15 years of age and has been voluntarily or involuntarily committed to the DSWD in accordance with PD 1603 or the Child and Youth Welfare Code. Who may adopt? Filipino citizens and aliens may adopt. However, under the domestic adoption, Filipino citizens may adopt if he is of legal age, in position of full civil capacity and legal rights, of good moral character, has not been convicted of any crime involving moral turpitude, emotionally and psychologically capable of caring for children, in a position to support and care for his or her children in keeping with the means of the family, at least 16 years older than the adoptee, but this latter requirement may be waived if the adopter is the biological parent of the adoptee or the adopter is the spouse of the adoptee's parent, and he must be a permanent resident of the Philippines. For alien to be able to adopt under the law, he must have the same qualification with the Filipino citizen, with the following addition: that his or her country has diplomatic relations with the Republic of the Philippines. His or her government allows the adoptee to enter his country as his or her adopted son or daughter has been living in the Philippines for at least 3 continuous years prior to the filing of the application for adoption, and maintain such residence until the adoption decree is entered. He has been certified by his or her diplomatic or consular office in any appropriate government agency that he or she has the legal capacity to adopt in his or her country. This requirement may be waived if he is a former Filipino citizen who seeks to adopt a relative one who seeks to adopt the legitimate son or daughter of his or her Filipino spouse. One who is married to a Filipino citizen and seeks to adopt a relative within fourth degree of consanguinity or affinity of the Filipino spouse. A Filipino citizen may adopt a child provided he or she is a permanent resident of a foreign country, has the capacity to act and assume all the rights and responsibilities of parent or parental authority under Philippine laws. He has undergone the appropriate counseling from an accredited counselor in country of domicile, has not been convicted of a crime involving moral turpitude, eligible to adopt under Philippine laws, in a position to provide the proper care and support and to give the necessary moral values and example to all his children, including the child to be adopted, agrees to uphold the basic rights of the child as embodied under the Philippine laws, the UN Convention on Rights of Child, and to abide by the rules and regulations issued to implement the provisions of the Inter-Country Adoption Act. Residing in a country with whom the Philippines has domestic relations and whose government maintains similarly authorized and accredited agency, and that adoption is allowed in that country. He or she must possess all the qualifications and none of the disqualifications provided in the Inter-Country Adoption Act and in other applicable Philippine laws. Is 27 years of age at the time of the application and at least 16 years or older when the child to be adopted at the time of application, unless the adopter or the parent by nature of the child to be adopted, or the adopter is the spouse of the parent by nature of the child to be adopted. For aliens under the Inter-Country Adoption Law, he or she must be at least 27 years of age at the time of the application, at least 16 years or older than the child to be adopted at the time the application, unless the adopter is the parent by nature of the child to be adopted or the spouse of such parent, has the capacity to act and assume all rights and responsibilities of parental authority under his national laws, has undergone the appropriate counseling from the accredited counselor in his or her country, has not been convicted of a crime involving moral turpitude, eligible to adopt under his or her national law, in a position to provide the proper care and support and to give the necessary moral values and example to all his children, including the child to be adopted, agrees to hold the basic rights of the child as embodied under the Philippine laws, the UN Convention on the Rights of the Child, and to abide by the rules and regulations issued to implement the provisions of the Inter-Country Adoption Act, and comes from a country with whom the Philippines has diplomatic relations and whose government maintains a similarly authorized and accredited agency, and that adoption is allowed under his or her national laws. He possesses all the qualifications and none of the disqualifications provided in the Inter-Country Adoption Act and other applicable Philippine laws. The procedure. In Inter-Country Adoption Act, where to file the application, it is filed either in the family court having jurisdiction over the place where the child resides or may be found, or through the Inter-Country Adoption Board through an intermediate agency, whether governmental or an authorized and accredited agency in the country of prospective adoptive parents. After the filing, if filed with the family court, the court determines sufficiency of the petition in respect to form and substance, and after which the petition is transmitted to the Inter-Country Adoption Board. If the petition is already with the ICAB, it conducts matching of the applicant with an adoptive child. After matchmaking, the child is personally fetched by the applicant for the trial custody, which takes place outside of the Philippines. What is supervised trial custody? This process takes place outside of the country and under the supervision of the Foreign Adoption Agency. It is for the period of 6 months. If unsuccessful, the Inter-Country Adoption Board shall look for another prospective applicant. Repatriation of the child is to be resorted only as a last resort. If successful, the ICAB transmits a written consent for adoption to be executed by the Department of Social Welfare and Development, and the applicant then files a petition for adoption in his or her country. The decree of adoption issued by a foreign court is required to have a successful inter-country adoption, or to have the child successfully adopted by the foreign adoptive parent. Consent required. A written consent of biological or adoptive children above 10 years of age in the form of a sworn statement is required to be attached to the application to be filed with the family court or the ICAB. If a satisfactory pre-adoptive relationship is formed between the applicant and the child, the written consent of the adoption executed by the Department of Social Welfare and Development is required. The cost of inter-country adoption. Upon filing of the petition for adoption, the prospective applicant will have to pay $2,000 for a single placement and $3,000 for sibling group or of 2 or more prospective adoptive child. Then for documentation, have to pay 400 pesos for the PSA birth or founding certificate. Then 1,200 pesos for the electronic passport. Then the certification issued by the Commission on Filipino Overseas, it costs 280 per document. And for the documents that require authentication from the Supreme Court, the Department of Health, the DFA, the Department of Social Welfare and Development, the birth or founding certificate has a documentation fee of 250 pesos per document. For the deed of voluntary commitment or declaration of abandonment or DSW certificate of child legally available for adoption, it's also 250 per document. For the placement authority, 250 per document. Placement proposal, 250 per document, 250 pesos per document. And for medical evaluation report or medical certificate, it is also 250 pesos per document. Here is the summarized steps for the inter-country adoption process. First is the filing of the application with the ICAB through a foreign adoption agency. The prospective foreign adopter may also file with the regional trial court or the family court. However, the court will, after determining the sufficiency of the petition in form and substance, will have to transmit the same to ICAB. So second is the child recommended for inter-country adoption certifies that inter-country adoption is in the best interest of the child. It is the DSWD who will certify and recommend for inter-country adoption of a child previously committed to the Philippine government. Then the matching. We have the Inter-Country Adoption Placement Committee matches the child with a person or couple interested in adopting and refers its proposal back to ICAB for approval. The Inter-Country Adoption Act of 1995 specifically prohibits contact between the child and the prospective adoptive parent or parents before such matching has been approved by the board. The Placement Authority. The Inter-Country Adoption Board notifies the Foreign Adoption Agency of its matching decision within 5 days. The adoptive parents have 15 days to respond. If they agree to the proposal or proposed match, the board issue a certificate or placement authority within 5 days. This placement authority allows the applicant to take custody of the child. Then the fifth step is the visa applications. The child appears at the appropriate foreign embassy for his or her visa interview. The Inter-Country Adoption Board serves as a proxy for the adoptive parent. The ICAB prepares all the necessary documents and fees, including the passport and medical examination. Then the sixth step is the child travels to a foreign land. The Inter-Country Adoption Act requires the adoptive parent or parents to escort the child from the Philippines to the country of destination. The adoptive parent or parents must arrive no later than 30 days after the appropriate visa has been issued. Then the seventh step is the supervision of trial custody. Upon assuming custody of the child, the applicant enter a 6-month trial period, where the accredited foreign adoption agency monitors the child's welfare. Then, number 8 or the eighth step is the petition for adoption. The foreign national's adoptive parent should file an adoption petition with the court of his home country within 6 months of the completion of the trial custody. Then the final adoption decree is issued by the foreign court, the trial court, in the home country of the foreign adoptive parent. So then the final adoption decree is issued by a foreign court and should be submitted to ICA within 1 month from issuance. That completes the inter-country adoption process.
Good evening, classmates. Good evening, Dean. I am Attorney Paul Centilla Zaidi from Iligan City. Tonight, I will be reporting about Republic Act 1122-2, otherwise known as Simulated Birth Rectification Act of 2019. This law is actually about adoption in the Philippines without going to court and the correction of fake birth certificates. Now, what is Republic Act 1122-2? And what are the important provisions of this act? Now, simulated birth record or simulation of birth record refers to the tampering of the civil registry to make it appear in the record of the birth that a child was born to a person who is not such child's biological mother, causing the loss of the true identity and status of the child. And what are the salient features of this law and its implementing rules and regulations? Now, granting the amnesty and allow the rectification of the simulated birth of a child to exempt from criminal, civil, and administrative liability those who simulated the birth record of the child prior to the effectivity of this act, provided that a petition for adoption with an application for the rectification of the simulated birth record is filed within 10 years from the effectivity of the law. Provide for and allow a simpler and less costly administrative adoption proceeding and administrative rectification of the simulated birth record of such child. This law also applies to adult adoptees. Foreigners could not avail of the provisions of the law except when they are married to a Filipino who is qualified under the law. Prospective adoptive parents who are not the parents named in the simulated birth certificate of the child could not file a petition for administrative adoption under this act. There is also a mandatory appearance by the petitioner and the child before the DSWD regional director. The purpose is to personally determine the identity of the parties and motivation to adopt before recommends to the secretary. Now, there is a transitory provision that allows the petitioner to either withdraw the pending case in court and file it with the department or continue with the judicial proceedings. Provision of pre- and post-adoption services to the petitioner, child, and birth parents if available. Conduct of case study report by the DSWD Field Office Social Worker. Now, Republic Act 1122-2, otherwise known as Simulated Birth Rectification Law, was signed into law on February 21, 2019 and officially took effect on March 29, 2019 after its publication. It primarily provides for the administrative adoption of children whose births were simulated prior to the law and the correction or rectification of the birth certificates which were issued because of the simulation. Now, the Department of Social Welfare and Development, which is the lead agency in the implementation of the law, promulgated implementing rules and regulations on October 2019. Now, when can I avail of Republic Act 11-2022? Now, your child is below 18 or is above 18 but cannot take care of himself due to physical disability or mental handicap. You have consistently treated the child as yours, and the child's best interest was why you placed your name on his birth certificate. Your child has lived with you for at least 3 years before March 29, 2019. If you go through a simulated birth now, Republic Act 11-2022 will not apply. You have simulated the birth of the child to make it appear that he or she is your own child, and the simulation is for his or her own best interest. Now, what are the qualifications to become an adoptive parents? Number 1, you should be a Filipino citizen. Second, you should have full civil capacity and legal rights. You should possess a good and moral character. You should be able to support the child. You should have not been convicted of any crime. If your spouse is a foreigner, he must have lived in the Philippines for at least 3 years before the filing. And you should be emotionally and physically capable of carrying the child. And lastly, you should be of legal age. Now, what are the documents to be attached in the filing of the petition? Now, these are the documents. Number 1, authenticated copy of the simulated birth record of the child and the birth certificate of the adopters. If the simulation of the birth was done by a third person, an affidavit of admission is required. Now, certification to be issued and signed by the head of the barangay attesting that the adopting parents are residents of the barangay, the petitioners are indigent if applicable, the child has been living with the adopting parents for at least 3 years before March 29, 2019, and certificate of attendance by the petitioner in a pre-adoption for and seminar. Oldest and recent photographs of the prospective adoptee and the petitioners within the last 3 months prior to the filing of the case. Notarized affidavit of at least 2 disinterested persons who reside in the same barangay where the child resides, proving that the child has been living with adopting parents for 3 years prior to the effectivity of the law. As applicable, marriage contract, decree of annulment, declaration of nullity of marriage, decree of legal separation, latest NBI or police clearance, authenticated copy of the negative certification of birth to serve as the basis for the late registration and issuance of rectified birth record. Original copy of the certification declaring a child legally available for adoption, issued by the DSWD, except when the prospective adoptee is an adult or a relative of the adopting parents within the 4th degree of consanguinity or affinity. Latest physical and medical evaluation of the petitioners by a duly licensed physician. When appropriate, a psychological evaluation of the adopters by a licensed psychologist. And the latest income tax return of or any other document proving financial capability, showing that the adopters have the financial capability to adopt the child. Now, what is the process in the filing of the administrative adoption and rectification of simulated birth? Number 1 is the assessment of the petition. Now, the petition for administrative adoption with rectification of the simulated birth must be filed with the Social Welfare and Development Office of the city or municipality where the child resides, which will make a determination if the petition is sufficient in form and substance within 7 days from filing thereof. If the petition is sufficient in form and substance, the Social Welfare Development Office shall submit the same to the regional director, where the office is situated, within 3 days from the determination and evaluation. If not sufficient, the same number of days, the same shall be transmitted back to the petitioner, stating the grounds of the denial. Second, the field office social worker shall then prepare a social case study report for the adopting parents and the child based on home visits, a determination of the identity of the child, the capacity of the adopting parents to care for the child, and that they have treated the subject adoptee as their own child. The report shall be accompanied by determination whether or not the adoption is to the best interest of the child. Now, the regional director of the DSWD shall review the findings together with the petition submitted by the social worker, who shall then prepare a recommendation whether or not to grant the adoption within 30 days from receipt of the social case study report. The petition, together with all the supporting documents, report, and recommendations, shall then be submitted to the Secretary of the Department of Social Welfare and Development. Upon review of the petition and all papers pertaining thereto, the Office of the Secretary of the DSWD shall then issue an order either granting or denying the adoption. If the adoption is granted, an order of adoption, which is registrable civil registry document, shall be issued stating the name by which the child will be known, and will likewise direct the concerned local civil registrar about the cancellation of the simulated birth record of the child and the issuance of a new birth certificate for the child who will be adopted. The order granting or denying the administrative adoption shall then be transmitted back to the regional office of the DSWD, which will notify the adopting parents, and in case the adoption is granted, to the local civil registrar concerned and the central office of the Philippine Statistics Authority, or PSA. The order shall be final within 15 days from receipt thereof by the adopting parents. Upon receipt of the certificate of finality of the order of the Secretary of the DSWD, the local civil registrar concerned shall then cancel the current birth certificate of the child and cause the issuance of new birth certificate indicating that the petitioners are now the parents of the child. Now, what you are seeing now is the flow chart of the administrative adoption procedure, by which it is shown step by step, to make it appear more simpler, to make it appear more simple. Okay. And this has been your reporter for the evening. I am Attorney Paul Zaidi from Ligan City. Now signing off. Thank you very much.
Hi, I am Attorney Rejoice Abihano, and tonight we are on an exciting topic in the adoption, which are the expectation versus reality. Now, in adoption, there will always be that expectation versus reality. The adopting parents will always have the desire of having a little angel in the family, or should we say, a bundle of joy. But what if that little angel turned out to be the little monster, or that bundle of joy turned out to be the bundle of grief? Watch this. So my friends, reality bites. What if this happens in the family? What is then the remedy of the adopters? Number two, what is the remedy of the adoptee in case the adopter turned out to be abusive parents? But before we are going to discuss all this, we will have to look into the effects of adoption. What are the effects? What are the legal effects of adoption? Number one, on parental authority. On parental authority, all parental authorities are now vested on the adopters. The relationship between the adoptee and the biological parents are already severed. Therefore, parental authorities are now, all parental authorities are now vested on the adopter. Second, on legitimacy, the moment adoption takes place, the adoptee is now raised to the level of a natural, legitimate child of the adopter. So for all intents and purposes, the adoptee is now a natural, legitimate child of the adopter. On succession, now Section 16 of Republic Act 8552 is very specific that in case of succession and in the event there is an adoption, the adopter and the adoptee shall have reciprocal rights of succession. In other words, what the law is saying is that the adoptee can inherit from the adopter and the adopter can inherit from the adoptee. Part of this on succession is the right to representation. Because what if the adopter predeceased the adoptee? Can the adoptee has the right, or can the adoptee represent the adopter in succession on the inheritance of the ascendants of the adopter? Republic Act 8552 is very specific on this aspect. Unfortunately, there is no right of representation granted on the adoptee. Why? Because in adoption, that relationship is exclusive only between the adopter and the adoptee. In other words, that relationship does not extend to the ascendants of the adopter and to the descendants of the adopter. Now, one more thing on succession. Can the adoptee inherit from his or her biological parents? Now, the law is very clear on this. The adoptee cannot anymore inherit from his or her biological parents except on testate succession. In other words, the biological parents, if in the event that the biological parents executed a last will and testament, thereby giving portion of it from the inheritance to the adoptee, that is the only way, that is the only time that the adoptee can inherit from his or her biological parents. Now we are on the most exciting part in our topic, and that is rescission of adoption. Can the adoptee seek judicial rescission of the adoption? Interestingly, Section 19 of Republic Act 8552 lay down the grounds where the adoptee may seek judicial rescission of the adoption. Number 1, maltreatment. Number 2, attempt to life. Number 3, sexual assault or violence. And number 4, abandonment and failure to comply with parental obligations. Now, these are the only instances where the adoptee may seek judicial rescission of the adoption. The happening of any of these incidents, maltreatment, for example, whether physical or verbal abuse, attempt to life, of course, we know that an attempt to life, there must be an overt act in committing this particular crime. Then sexual assault or violence and abandonment and failure to comply with parental obligation. The happening of any of this ground entitles the adoptee to seek judicial rescission. Now, who may file the judicial rescission? Can the adoptee himself or herself file the same in court? Yes. If the adoptee is already of legal age, he or she may file the judicial rescission, the petition for judicial rescission. In the event the adoptee is still a minor, the DSWD can file for and in behalf of the adoptee. Now, can the adopter also seek judicial rescission of the adoption? This is very interesting because while this right is granted on the adoptee, can the adopter also seek judicial rescission of the adoption? Interestingly, under the old civil code and was also copied in the Presidential Decree 603, eventually translated also in our family code, all these laws allow the adopter to seek judicial rescission of the adoption. However, when Republic Act 8552 was enacted into law, all these were deleted. At present, the adopter may not seek for judicial rescission of the adoption. The reason of the law is that it is for the best interest of the adopted child. However, the adopter, in case of change relationship, or the adopted child turned out to be so different and commit acts which are inimical to the interest and health of the adopter at this time has been granted by law to disinherit the adoptee. But that is the only extent that the adopter can avail of in case of acts committed by the adoptee against the adopter. Now, an interesting case came out because in this particular case, the adoption took place under the old civil code. And then it was processed and the adoption was granted. And remember that under the old civil code, the adopter has the right to seek judicial rescission of the adoption. As years pass, the relationship turned sour between the adopter and the adoptee, and now the adopter seeks for judicial rescission of the adoption. Question was, can the adopter seek judicial rescission of the adoption in the passage of Republic Act 8552? Now, this was the issue that was brought before the Supreme Court. The petitioner argued that, hey, our right is already vested. That right to rescind, to seek for rescission of the adoption was already vested because the adoption was procured or was granted under the old civil code. And therefore, having that vested right, it cannot be removed from them to seek for judicial rescission of the adoption. The Supreme Court, in denying the petition, said, while adoption has often been referred to in the context of a right, the privilege to adopt is itself not naturally innate or fundamental, but rather a right merely created by statute. It is a privilege that is governed by the state's determination on what it may deem to be for the best interest and welfare of the child. Matters relating to adoption, including the withdrawal of the right of an adopter to nullify the adoption decree, are subject to regulation by the state. Concomitantly, a right of action given by statute may be taken away at any time before it has been exercised. And finally, we are on the effects of rescission. What are the effects in the event the court grants judicial rescission of the adoption? Now, here are the effects. Number one, parental authority of the adopter is terminated. Number two, parental authority of the biological parents is restored. Number three, legal custody of the adopter is, of course, terminated. Number four, legal custody by the biological parents, if known, of course, or if unknown, the DSWD is also restored. Next, the amended birth certificate pursuant of the adoption shall be cancelled, and the original birth certificate pursuant of the adoptee shall be restored. And last, successional rights. The successional rights of the adoptee to his or her biological parents is also restored. But only at the date of judgment of rescission. Meaning, those rights already vested prior to the grant of the judicial rescission must be respected. In other words, what is contemplated by law? If in case the biological parent or a biological parent had already died, and then inheritance had already passed to the heirs of that biological parent, and subsequently a judicial rescission was granted on an adoptee, can the adoptee still ask his or her share from the other siblings of his biological parents? The answer is no. That has to be respected because there is no retroactive effect on the grant of judicial rescission. Friends, thank you for joining me. And my companion will report, Attorney Passes, will report on discrimination and single parent adoption. So stay tuned. Thank you.
Good evening. I am Attorney Zarina Maybelline V. Passis, and I will discuss the topic on discrimination in our adoption laws. But before we proceed to the discussion of the topic, let us take a look at this short video on how adoptees or ampon are being portrayed by the media.
Teka, sandali! Sandali lang! Hinto niyo to! Hoy, ikaw! Ang kapal din talaga ng mukha mo, no? Parang hindi ka mabubuhay hanggat wala si atensyon ng mga tao. Pati korona ko, inagaw mo na rin!
Bakit ba kasi bumalik-balik ka pa dito, ha? You don't have a place to be here. Quintana lang ang pwede maging Reyna Elena. Bakit? Ano bang feeling mo? Quintana ka pa rin? Eh, ampon ka lang naman, ah!
As you just observed, the Filipino mainstream media has generally portrayed an adoptee or ampon in a very negative light. I'm sure that most of us have already watched drama series with a similar plot or storyline. The main character or protagonist is an adoptee or ampon, but before he or she lives a happily ever after, he or she must undergo a series of physical or verbal abuse, bullying, humiliation, and even discrimination. However, for purposes of this report, let us move away from the public perception of an ampon or adoptee and how they are being discriminated against, and let us take a look at some of the critiques against our adoption laws and whether they are indeed discriminatory. The first thing that we find discriminatory is the provision under RA 11222 or the Simulated Birth Rectification Act with respect to the persons whose consent is necessary to adoption. To recall, under Section 9 of the Domestic Adoption Act, before a child can be successfully adopted, the written consent of the following individuals are required. Number 1, the consent of the adoptee if 10 years of age or over. Number 2, the consent of the biological parents of the child, if known, or the legal guardian, or the proper government instrumentality which has legal custody of the child. Number 3, the consent of the legitimate and adopted sons and daughters, 10 years of age or over, of the adopter and adoptee. Number 4, the consent of the illegitimate sons and daughters, 10 years of age or over, of the adopter, if living with said adopter and the latter spouse. And number 5, the consent of the spouse of the person adopting or to be adopted. However, when we look at RA 11222, only the consent of the following individuals are required. Number 1, the consent of the adoptee. Number 2, the consent of the legitimate and adopted daughters and sons. Number 3, the consent of the illegitimate daughters and sons. And number 4, the consent of the spouse. What is missing? As you can see, unlike the Domestic Adoption Act, which requires the written consent of the biological parents of the adoptee before the latter can be adopted, RA 11222 does not anymore require the written consent of the biological parents of the adoptee. We find this provision unduly discriminatory, if not utterly unjust, against the biological parents of the child. Why, you may ask? It must be recalled that the state intends to preserve the natural bond between the biological parents and the child. The main purpose of requiring the consent of the biological parents of the adoptee is to ensure that the biological parents have knowingly and voluntarily relinquished their inherent natural parental authority over their child. It must be noted that the Constitution provides that the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. On the other hand, under our laws, it is a declared policy of the state to ensure that every child remains under the care and custody of his or her parents and be provided with love, care, understanding, and security towards the full and harmonious development of his or her personality. However, because of RA 11222, which dispenses with the written consent of the biological parents of the adoptee, it is as if the law has completely disregarded the state's policy of giving primacy to the rights of the biological parents over their child. RA 11222 does not even make a distinction as to whether the biological parent is known and can be found. This is very dangerous because after the adoption decree has been issued, all legal ties between the biological parents and the adoptee shall be severed, and the same shall be vested in the adopter. In our opinion, the written consent of the biological parents of the child thus becomes indispensable. We submit that a mere certification declaring a child legally available for adoption is not enough, and it cannot substitute for a written consent of the biological parent, if known, which is the most definitive proof of a parent's relinquishment of his or her parental right over his or her child. The written consent of the biological parent is all the more needed because the adoption under RA 11222 is administrative. Speaking of administrative procedure, we now go to the second discriminatory provision, which is still under RA 11222. To recall, one of the objectives under RA 11222 is to provide and allow for a simpler and less costly administrative adoption proceeding where the child has been living with the person or persons who simulated his or her birth record for at least 3 years before the effectivity of the act. In other words, under RA 11222, the adoptive parents only have to undergo the administrative procedure for adoption. No court intervention is required. This is a blatant departure from the procedure under the Domestic Adoption Act, which requires the adopters and all the parties involved to undergo 2 phases of adoption: the administrative process as the first phase and the judicial process as the second phase. Under the Domestic Adoption Act, the court issues the adoption decree. However, under RA 11222, an administrative adoption order issued by the DSWD Secretary shall have the same effect as a decree of adoption issued pursuant to the Domestic Adoption Act. We find this provision discriminatory because RA 1122 in effect created 2 classes or sets of individuals. The first set are those parents who are law-abiding citizens and who did not simulate the birth certificate of the adoptee. On the other hand, the second class of individuals are the adoptive parents who are also perpetrators of the law but who were granted exemption from criminal, administrative, and civil liability under RA 11222. The adoptive parent who simulated the birth certificate only has to undergo a simple administrative procedure. By giving to the criminal perpetrators the advantage of obtaining adoption decree through the simpler and faster administrative process instead of undergoing the longer and more costly judicial process, the law discriminated against adopters who did not simulate the birth certificate. Now, moving away from RA 11222, let us look at whether there are still some discriminatory provisions under our adoption laws. Under Section 9 of the Domestic Adoption Act, the written consent of the adoptee is required only if he is 10 years of age or over. This provision gives rise to some questions. Is there a substantial difference between a 10-year-old and, let's say, a 9-year-old, or a person who is just short of 10 years old? What about their written conformity? Why dispense with their written consent? Is it because it is useless, because they are incapable of giving consent? But under the law, an 8-year-old, a 10-year-old, or a 12-year-old child are all minors and hence incapable of giving consent. On the other hand, we look at the Inter-Country Adoption Act vis-a-vis the Domestic Adoption Act. Under the Inter-Country Adoption Act, the adopter, who may be an alien or a Filipino citizen residing abroad, must be at least 27 years of age and at least 16 years older than the adoptee. However, when we look at the Domestic Adoption Act, the 27-year-old minimum age requirement is not present. Only the 16-year age gap is required. We find this distinction quite questionable, as it appears that those who are adopting under the Inter-Country Adoption Act are given stricter requirements. By imposing the 27-year-old age requirement as compared to Filipinos or aliens who are adopting under the Domestic Adoption Act, which does not require a minimum age, but only a 16-year age gap. However, this is just a minor observation. As a final point, it is not amiss to state that one of the common critiques against our adoption laws is that it is discriminatory against the same-sex couples or LGBT couples. As discussed earlier, one of the eligibility requirements for married couples under Section 7 of the Domestic Adoption Act is the joint adoption by the husband and the wife. The word husband refers to the traditional male person and wife refers to the traditional female spouse. Notably, same-sex couples may not file for joint adoption because same-sex unions are not yet recognized under Philippine laws. However, it must be noted that an individual or a solo parent, regardless of his or her sexual orientation, may file a petition for adoption. He or she just needs to meet the eligibility requirements of an adopter under the Domestic Adoption Act or the Inter-Country Adoption Act. As a matter of fact, in a previous newspaper interview with the head of the DSWD Alternative Care Division, Ms. Sally Dagulo, it was emphasized that adoption is an option available to solo parents and not just to married couples. She mentioned that DSWD is gender sensitive and does not judge the prospective parent based on his or her sexual orientation. As long as the applicant meets all the requirements and has shown the proper motivation for wanting to care for a child, he or she will be considered. Besides, it must be noted that gender or sexual orientation is not an eligibility requirement. In that regard, our adoption laws are not discriminatory.
Good evening, Dean Mel, and good evening, classmates. I am Judge Ishak Mangundato, and the task assigned to me is to discuss surrogacy in the Philippines. Despite having a booming population of more than 100 million, the Philippines still has problems when it comes to infertility. According to a survey, 1 in 10 Filipinos suffer from infertility. Thus, couples resort to assisted reproduction or infertility treatment such as artificial insemination and IVF. However, there are instances where it is the woman who is not capable of bearing or delivering a child, like the case of Corina Chances. This may be due to the defective ovarian cells or an inhospitable uterus. Adoption may not be available for these couples either because of lack of children available for adoption or they wanted to adopt only their relatives. Thus, surrogacy seems to be their only available option. What is surrogacy? Surrogacy is a process wherein a surrogate, a woman, bears and carries a child for another through medically assisted reproduction and pursuant to a written agreement between the surrogate and the intended or commissioning parents. What are the types of surrogacy? Surrogacy is classified according to the method used and according to purpose, cause, or object. According to method used, traditional, it's either traditional or gestational. In traditional surrogacy, the surrogate is inseminated by the commissioning father's sperms, either naturally or via in vitro fertilization. Here, the surrogate, as the egg donor, has a genetic link to the child. In other words, the so-called surrogate mother is not only the woman who gave birth to the child, but the child's genetic mother as well. Number 2, gestational. The surrogate carries the embryo created by the union of the egg and the sperm of the commissioning couple. Example is the delectable twins of Mar and Corina. According to purpose, cause, or object, we have commercial and altruistic. Commercial surrogacy is an act wherein a person receives a payment, reward, or other material benefit or advantage for the person or another person. Altruistic surrogacy, on the other hand, refers to those surrogacy agreements where surrogate does not receive monetary compensation. In most altruistic surrogacy agreements, the surrogate is a close relation to the intended parents. How much does surrogacy cost? According to families through surrogacy, the approximate average cost of surrogacy in different countries ranges from as high as $100,000 in the United States and as low as $45,000 in. What is the process of surrogacy in the Philippines? To better understand this, let us take the case of Nora, not her real name. Her journey into surrogacy started when she came across a closed Facebook group account which actually exists today for surrogate mothers. She tried to join but was rejected immediately, surrogacy being taboo in the Philippines. A few days later, a Filipina based abroad asked if she was still interested to be a surrogate. The offer is ₱500,000 to carry a baby to full term plus 10,000 pesos per month for food, transportation, checkup, etc. until delivery. The transaction happened online. She accepted the offer, flew to Manila, and met the intended Black American parents and signed the contract with them. It had clauses that meant abandonment of her three kids for more than a year, no sexual contact with her husband, and a promise of no claim to the baby after birth. After signing the contract, she flew to Greece to have the embryo transferred via in vitro fertilization. In 2017, she gave birth to a healthy baby boy with the intended parents waiting outside the delivery room. After the birth, the baby's umbilical cord was cut and the baby handed over to the intended mother. There was no skin to skin for Nora, the most important first encounter of a mother and her newborn child. That privilege went to the child's intended mother. Now, there is no doubt that surrogacy is approved by science, as it is the result of advances in science and medical technology. However, there are some ethical, moral, and legal problems or issues surrounding it. Medical ethics. According to Rudy Frederick Mendiola, Capto Biotic Center Medical Director, although there is a need to treat infertile mothers in the Philippines, but because of ethical considerations, surrogacy is not openly done here in the Philippines. Members of the Philippine Society of Reproductive Medicine agreed that as long as there is no clear law that protects the couple, the surrogate, and the baby, it will be very difficult to do it here because it will be very complicated. There could be a lot of problems. There are many ethical issues. Also, the church is against it. In 1987, Vatican released a document called Dono Vitae, which explained the church teachings on surrogacy and other artificial technologies. According to the document or to the church, the productive technologies must only assist but not replace the marital act of couples in joint in marriage. Thus, the church does not agree with and in fact condemns surrogacy because it replaces the union of couples to produce an offspring. What is the Sharia or Islamic law's perspective on surrogacy? In making a legal ruling, Muslim scholars consider the maqasid al-Sharia or the purposes of the law. Among the maqasid of Sharia is hifd an-nafs or the protection of progeny. Thus, the Council of Islamic Faith Academy declared that surrogacy, which is gestational, is Islamically forbidden and absolutely prohibited due to the consequences of the lineage, confusion, and loss of motherhood. In other words, since the surrogacy is against one of the purposes of Sharia, that is protection of progeny, it is considered haram, or it is not allowed. Now, what are the legal effects of surrogacy in the Philippines? Are the persons who participated in surrogacy criminally liable? The answer is no. In the absence of a law specifically penalizing surrogacy, the surrogate mother and all those who participated in surrogacy are not criminally liable. However, once the intending parents or commissioning parents register the birth of the child and declared in a certificate of live birth that the mother is the intended mother, the latter might be held liable for simulating birth certificates penalized under the revised penal code. Now, what is the status of the child? Under Article 164 of the Family Code, a child born outside of marriage is an illegitimate, regardless of the means by which he or she was conceived. Hence, if a child is born to a surrogate mother, regardless if it is traditional or gestational, the child is illegitimate and this status will appear in his or her birth certificate. The intended or commissioning parents can improve the status of the child. Now, what is the who will be registered as mother of the child? Is it the surrogate or the egg donor? In the absence of law on surrogacy, it is the surrogate mother under the Civil Registry Act. Under the latter law, The traditional or conventional notion of mother is one who conceives, bears, and delivers a child, either by normal or C-section procedure. It is likewise the legal notion of motherhood. Thus, the filiation of the child to his or her mother is determined by childbirth. As for paternity, the legal framework is rather simple. Through marriage with the mother of the child or acknowledgement of the child by the father in a public document. However, the situation would become complicated if the surrogate mother is married and has her own children. Who will be registered as the father of the child? That's the question. What is the citizenship of the child born through surrogacy? Under the 1987 Constitution, the child follows the citizenship of the Filipino mother or father. Thus, if the surrogate mother and the intended father are Filipinos, then the child is a Filipino, and this will appear in the child's birth certificate. However, a problem might arise when the father or commissioning parent has a different citizenship. It may later present an issue on dual citizenship which may disadvantage the child in the future. Also, another problem would arise if the surrogate mother is not Filipino. Now let's go to the validity of the commercial surrogacy. Question R, is commercial surrogacy valid and enforceable in the Philippines? How about altruistic surrogacy? Suppose that the surrogate mother has developed love for the child she has been carrying in her womb for 9 months. Siyempre, matagal na yun. And after delivery, refuses to turn over the child to the commissioning parents. Can the latter enforce the agreement in our courts? The answer is no. The contract of surrogacy in general is not valid and enforceable as it is contrary to law. Paternity, filiation. This is because paternity, filiation, custody, and parental authority are defined by law. Commercial surrogacy, on the other hand, is not valid as it is not only contrary to law but also against morals, good customs, public policy, and even public welfare, because our Constitution upholds the dignity of every human being. As correctly explained by Senator Manny Villar, the idea of negotiating pregnancy by commercial contract should be abhorrent to anyone who believes in the dignity of human life. Commercialized surrogacy reduces women to the status of breeding animals, their wombs rented, their eggs bought and sold in much the same manner as commercial livestock. Out of poverty, foreign nationals or entities may lure our poor women to become surrogate mother for a promised fee. Thus, in this manner, there is a difference between surrogate motherhood and black market baby selling. Therefore, if the surrogate mother would take the baby and decides to breach the contract, Philippine laws will protect the mother who bore the offspring since it is assumed that she is the legal mother. The intending parents cannot enforce the law or the contract because it is void. Now, considering the issues discussed earlier, the following are the possible legislative options offered by Professor Elizabeth Pangalangan. Thus, number 1, prohibit all forms of surrogacy. This is the proposed bill of Senator Villar. However, according to Professor Pangalangan, a ban on all forms of surrogacy in the Philippines will not cover surrogacy services abroad and could only trigger the black market. Number 2 option, prohibit commercial surrogacy but allow altruistic surrogacy. A relative or friend could be a surrogate as long as no money is involved. However, the question of ethics remains. Number 3 option, regulate commercial surrogacy, more particularly the fees. According to Professor Pangalangan, offering higher fees to entice women to become surrogates against their better judgment is one possible outcome of surrogacy. But lowering the fees, on the other hand, would also mean exploiting them for a hard service done. Number 4 option, the state can also choose not to regulate surrogacy at all, just like the current status of the Philippines. That ends my report, and thank you very much for listening, and good evening.
Good evening, ladies and gentlemen. Good evening, Dean Mel Santa Maria. I am Attorney Yvette H. Samper, and I will be your final reporter for tonight. I will be discussing other matters that you may have already known, but we just want to emphasize it for you tonight. Facts and figures concerning domestic adoption and surrogacy. Adoption through the DSWD is free. It will not cost you a thing, only that the paperwork and the legal processes of getting the requirements done would cost the applicants some money. More than 350,000 children were born in the first 3 months of 2019, but sad to say, not all of them are in good home. 2,191. This figure represents children that have been placed in domestic adoption between the years of 2010 to 2018 in the Philippines. 19,514. This figure represents children adopted in the US in 2012. 49 in 100,000 adults as adoptive parents. It means that this is the adoption rate per 100,000 adults in 2012 in the US. So meaning 49 persons are adoptive parents out of 100,000 in the US. Let's talk about facts and figures concerning surrogacy. Surrogacy is still illegal in the Philippines. So here are some data regarding the countries where commercial surrogacy is legal. USA, legality varies by state, available to both homosexual and heterosexual foreigners. India, only available to Indian citizens. Georgia, only available to heterosexual couples, including foreigners. Legal rights of intended parents are well protected, the most common hub of surrogacy as of now. Russia, available to heterosexual and single women. Kenya and Greece, Laos, Ukraine, these are also countries where commercial surrogacy is legal. Here are the top 3 cheapest countries to avail of surrogacy services. So Georgia, Ukraine, and Russia. For Georgia, it will cost you 1.5 to 1.8 million to have surrogacy services. Ukraine, 2.4 to 2.8 million. Russia, 2.2 million to 2.8 million. And in the Philippines, it's still illegal in the Philippines, but according to Judge Mangandato in his report, you will be amazed and in shock that there are baby makers already posting their services on Facebook. But then again, it's still illegal. So that ends my report, and the references for my report are posted here, and thank you very much. Good night.